Our question is what's the procedure on this? Who does what? And one of the things that we're finding is that because the supervision is being done by the court service or community corrections officer, those are the folks that are going to be bringing this presumptive discharge to the court. And there is nothing in the statute that talks about procedure at all. But one of the things that we're encouraging is notice to all the parties. So that if that prosecutor wants to object to the individual on the presumptive discharge, the court certainly wants to be aware of those type of things as well, that everybody be noticed up so that if a hearing needs to actually be held, it can actually go forward. Otherwise, hang on just a second. So essentially that's what's actually being, a notice of discharge or a order of discharge or something of that nature would actually be drafted, and that would actually be noticed up to the parties as to whether or not this is the situation. With regard to your month question, keep in mind if you've got an 18-month probation, offender screws up for the first 6 months, but then for that next 12 months, that's okay. It's a consecutive time period so that, if they would have a longer period, it doesn't have to be from the start. It could be any 12-month consecutive time period that they're okay. But if they've paid their restitution, they're low risk, and they've done those things, then they would be eligible for doing that. And that's something, what you're saying as far as being compliant, that's going to be something that your local jurisdiction is going to have to make a decision as to what does that actually mean under statute.